Hi there. I'm not sure who all's here. This is Melissa. I'm here with Michelle Dellino from Dellino Law Group, and we're here to host our webinar today. Michelle's going to introduce our topic, and then we'll tell you a little bit about ourselves before we get started. I think some people are still kind of logging on right now, so I'll give a few more minutes maybe before we totally get rolling. But just a couple of quick things. Please be sure if you have questions to put them in the Q&A. After Michelle speaks a little bit about our topic today, we're going to be able to pull some questions, and we'll pull them out of the Q&A. You can choose to post your question anonymously, or you can choose to post it with your name. It's totally up to you, but we'll pull questions out of the Q&A, and Michelle will be able to field some of those at the latter part of the webinar. You can put them in chat, but I would prefer you put them in Q&A because it's easier to pull them from one place. If you have anything that you want to just make a comment to myself or to Michelle, please put that in the chat. Michelle Dellino is our managing attorney and the owner of Dellino Law Group. And my name is Melissa Rosenberg, and I am a mental health provider. And I work alongside Michelle at the firm on the leadership team. I also have a therapy practice where I provide individual and couples counseling. I work with a number of the clients of the firm who are dealing with emotional hardship alongside their family law case, as well as clients outside in my own private practice as well. So I'm going to turn it over to Michelle to introduce our topic and talk to you guys more about what's going on today. But again, please utilize the Q&A feature at the bottom of the Zoom page and pop in there any questions you might have as she's talking, and we'll pick those up at the end of the webinar here. Okay, so welcome. Thank you for coming.
All right, awesome. Okay, thanks for coming. Looks like we have a bunch of people here. That's great. I'm Michelle Dellino from Dellino Law Group. Thank you for joining us. This is, let's see, it's our third webinar? I think so. Some of you have probably been here for all three. If you haven't, and this is your first time, welcome. We started doing these in the COVID era. I think it's a great way to share information about topics without having to leave your house. So I left my house today. I'm at my office, but we are here. We are socially distancing. We are practicing all of the things we need to be practicing, and we have a lot of space here. So it's been nice for us to get back into the office a little bit and still be able to do this. Today we're going to talk about spousal maintenance and child support in Washington. So those are two really hot button topics that everybody always wants to talk about. So I thought it would be a good idea to talk about them and give kind of a high level overview for people, because there really is no one-size-fits-all answer really to either of these two topics. So what I'm going to do today, just to give you an idea of what to expect, I'm going to talk about some basics that you might want to know or that you should know about these two issues. We'll probably spend a little bit more time on spousal maintenance because I think there's more variance there. I will touch on child support as well and the impact of child support on spousal maintenance, because I think that that's extremely important for people to understand that there is interplay between the two. And then when you have questions, last time we did a webinar, we had a lot of questions, and unfortunately we didn't quite get to them all. We even went over the hour a little bit, but I don't have a ton of time today. So to go over the hour, I have the whole hour, but I don't have a ton of time over the hour. So I want to make sure and leave enough time for questions. So what we will do is I will go through information, and I probably will have Melissa check in maybe a couple of times with questions if there are any, just because I really want to get to as many of your questions as I can, because the whole point of doing this really is for you, not me. Anyway, spousal maintenance. Let's talk about spousal maintenance. This is one of the things in Washington that comes up in almost, not every divorce, but a lot of divorces. And one of the reasons that spousal maintenance is such a hot button issue is the standards in Washington are different than other states. We don't have, like California has. California, I like to talk about California because a lot of people think that we are like them. We're a community property state, but we don't divide community property 50-50 like California does. We have spousal maintenance, but we don't have the same kind of formula like they do. So in Washington, we do things a little bit differently. What is the standard for spousal maintenance in Washington? There's one answer to that. it depends. And that's the answer that nobody really wants, but it is the answer that you're going to get because it depends on your case. And what does that mean? It means that a Washington court wants to know more about your marriage. And if you're going to be in a settlement situation, your settlement is likely going to be realistic and reflect what a court would do, or negotiation and compromise that are reflective of Washington law. So when you're looking at spousal maintenance, yes, there is a statute in Washington law that governs spousal maintenance, but there's also case law. So Washington law has statutory law, it has case law, and there are also other guidelines that courts in Washington, courts of general jurisdiction, have generally adopted to govern standards for spousal maintenance. So when I say that it depends, what does that really mean? It depends on, number one, the kind of questions I ask a client when I try to figure out what's maintenance going to look like for you. Number one, how long were you married? Because someone that was married 5 years or less, which is what we would call a short-term marriage, is going to have a totally different maintenance situation than someone who was married 25 years. So we want to know how long you were married. In Washington, well, like I said, it depends. So Washington maintenance is vague and discretionary, which means there's more to fight about, but it doesn't mean there are no standards. So length of marriage is one factor that's huge. Short-term marriages, generally speaking, I'm going to give you kind of guidelines. And again, these are not hard and fast answers. These are not necessarily what's going to happen in your case. So nothing I'm going to tell you is legal advice for your case. Nothing I'm going to tell you is necessarily true always, because like I said earlier, maintenance awards are what are generally called discretionary. So that means a court has discretion to award maintenance based on what the factors are that it hears and the information before it. So when you're working out a settlement and you never even go to court, you kind of are going by the same guidelines and thinking what a court might do and what Washington law recognizes. So let's talk again about length of marriage. So a short-term marriage. Courts kind of generalize a Washington marriage to be a short-term marriage if it's 0 to 5 years. Some judges will look at a Washington marriage as short-term if it's only 0 to 3, but it's become more and more acceptable that 0 to 5 is pretty much seen as a short-term marriage. In a short-term marriage, and also too, there's two types of maintenance. There is post-divorce maintenance and temporary maintenance. What I'm talking about now is post-divorce maintenance. So I'm talking about, and that's very important. Some of you might be in the middle of a family law case. If you're in the middle of a family law case, you may be dealing with temporary maintenance, and I'm going to touch on that. But right now what I'm talking about, and I want to clarify this, I'm talking about post-divorce. So if I'm talking about post-divorce, these would be maintenance awards after your divorce is final. So just keep that in mind. So short-term marriage, let's go back to that. Another thing too, you might have noticed, I talk fast. So this isn't necessarily a situation where you get to tell me to slow down because we're not sitting together right now. But if you miss something that I say, this will be available on YouTube later, so don't worry. You can always go back and watch it again. You can always email me if you have a question about something I said that you missed, or you can always ask a question, and Melissa will chime in and let me know later. So anyway, short-term marriages. So short-term marriages, the goal of maintenance is very different than a midterm or a long-term marriage. Goal of maintenance in a short-term marriage is basically to help the other party get back on their feet. It is more, marriages in general in short term are what we call backwards looking. They're looking to put the parties basically back where they were when they came into the marriage. They're looking to get people back on their feet, leaving the marriage in a situation that's sustainable for them, and not in a harmful situation where one person is living on the street and the other person's living in a home. We don't want that. But maintenance in a short-term marriage is really meant more as what you would call, I don't want to say a Band-Aid, but more rehabilitative, but for a very short period of time. It usually would be something that would be awarded if it was a 5-year marriage, maybe for a year max, and I'll talk about the standards shortly, but something for a very short period of time, and then it would taper off or it would just end. And the whole idea of maintenance would simply be to get somebody back on their feet. That's it. And then it's done. It's not a long-term solution. If you're in a short-term marriage, you're not expecting to get long-term maintenance. And it's also really important for people to know, hey, I was married 5 years. You're not going to get 5 years of maintenance. I've had people walk in the door and they have no idea, and it's not their fault. They don't know, but they walk in and they think, I was married for 3 years, or I was married for 4 years, and I stayed home the whole time, so I think I'm going to get 3 or 4 years of support. In Washington, it doesn't work that way. If you were married for a short period of time, you're going to get a short amount of maintenance. That's just how it works, and we'll talk about standards again in a minute. Midterm marriages. This is where there is absolutely the most room for ambiguity, and the most room for discussion, and the most room for the it depends way of looking at things under Washington law. And the reason why is, quite simply put, midterm marriages, some courts will see them as everywhere from being from 5 years to 25 years. So that's a big difference, right? Some courts will look at a midterm marriage as being from 3 to 20. It's kind of two different, a lot of different marriages can fall in between there. This is more where we come down to talking about what's a normal calculation for maintenance? Like, how do I figure how many years of maintenance I'm going to get? And again, this is not a hard and fast rule. What I'm going to tell you is a general idea, as if you had no idea about maintenance and you've never heard about it before. Let's say you're married for 20 years. Well, that would be a longer range midterm marriage. That means it's a long marriage. Most of your assets are probably going to be community. Most of them, not always, because you might have had pre-marriage assets, or maybe you have inheritance that's separate property, all kinds of other stuff. But it's a long marriage, and let's say one party stayed home. A very common scenario might be one party stayed home for a certain number of years and took a step back in their career to raise children. Or let's say that maybe the family moved for one party's career, another party left a job behind, and they relocated. So somebody's not at the same career progression as their partner. So 20-year marriage, what do you do? How long does somebody get maintenance? How much money do I pay? What happens, right? Let's use this as an example. 20 years would be a longer midterm marriage, like I said. So how do you calculate? Okay. Washington standards, and if anyone's talked to an attorney, you may or may not have heard this. Some people will tell you, and I say some people will tell you because it depends. Some attorneys will say, oh, it's always a 4-to-1 ratio. What does that mean? 4 years of marriage. So I like to write sometimes when I talk, so forgive me if I'm doing that. Helps me stay on track. 4 years of marriage is 1 year of maintenance. So a 4-to-1 ratio would be 4 years of marriage is 1 year of maintenance. So even I can do basic math, and I would know, okay, just if you think about it, 20 years, you divide it by 4, simple math problem, 5 years of maintenance, right? That's a pretty simple math problem. But it's not that simple, and let me tell you why. A 4-to-1 calculation is a standard, right? But it's not an absolute. A Washington court wants to know more about your marriage, which is what I said earlier. Maintenance awards can vary. A 3-to-1 standard might be more appropriate where one party is a middle 6-figure income and the other party is a stay-at-home parent with little to no education and no income potential in their early 50s. So maybe a 3-to-1 ratio comes into play. So what do you do then? You think about it and you say, okay, this person's going to need support longer in a 20-year marriage, and you take 20 and you say, okay, now we're looking at closer to 7 years, right? So you kind of come up with what a range might be. So 20-year marriage, I'd say low end is 5 years, high end, depending on the factors, might be 8. And maybe that's a little more than a 3-to-1 ratio, but it really depends on the factors that are involved in the marriage. And your attorney will probably tell you, depending on what side they represent, whether they represent the spouse that's going to be paying the maintenance, or whether they represent the spouse that is what we would call the financially disadvantaged spouse, or the spouse that's going to be receiving the maintenance, depending on what kind of advice you might have received. So 4-to-1 is a calculation that is thrown around a lot. So maybe you've heard it, maybe this is your first time hearing it, but if you're looking into maintenance, you'll probably hear it. But that's not an absolute. I've settled cases with a 3-to-1. I've settled one case recently, actually, which was a 2-to-1. And that was a pretty extreme situation, but that can happen. That is not the norm. So that would be like, gosh, let's say I had a 20-year marriage, I'm gonna get maintenance for 10 years. It happens, but not very often. So that's a midterm marriage. A more common scenario in a midterm marriage to think about, let's say you have the marriages that are the most contentious to figure out in maintenance are very often like a 15-year marriage where one party has gone back to work and they're making an income, but maybe they, aren't making as much as the other party. What do we do here? How does that look? How many years? That might be a more traditional 4-to-1 formula. And it probably is a maintenance package that tiers down. And what I mean by that is, how much am I going to get? Well, a very common way to look at figuring out how much maintenance is going to be is saying you can take the party's income, you can take how much, and that would be like net income after taxes, the amount that's allowed for voluntary retirement contributions, and everything else under the sun that has to come out if you have union dues or whatever else you have, and other expenses. And then you look at what your financial situation might be and what your budget is, and you look at what's left and you say, okay, what is our income and how do we best split it? So maybe then you leave the marriage on equal footing. So if the household combined income for both of you is $20,000, right? So let's say you're in a 15-year marriage. Party A makes, I don't know, 12,000. Party B makes 8. So you've got a combined income of 20. And you want the parties to leave each with 10. Again, we're back at, this is all very simplified, but we're back at like a simple math situation. Maybe party A is paying party B a little bit of maintenance. They're paying them $2,000 a month, and then they're equalized. So maybe they're paying that for a period of time, and then it steps down from $2,000 a month to a little bit less. And that's a very simple way to look at this. That is by no means a maintenance calculation, but just giving you an idea that it could be as simple as equalizing support right out of the gate on maintenance and then stepping down until that maintenance isn't needed anymore. But in a 15-year marriage, if you think about it, you could have all kinds of different scenarios. It depends on what the income discrepancy is. But in a 15-year marriage, you could be looking at probably around 4 years of maintenance would be a reasonable maintenance calculation in a typical scenario where one party is the primary breadwinner and the other party needs rehabilitation. And then you look at long-term marriages. So long-term marriages sometimes sound like they're going to be the most difficult maintenance situations, but very often they're not. And the reason why is that maintenance in Washington, there's case law in Washington that reflects what happens in long-term marriages. Long-term marriages in Washington are typically defined as 25 years or more, although I have seen Washington courts treat 20-year marriages as long-term, although it's arguable that's a reversible error if a lifetime maintenance award was issued in a 20-year marriage, because case law in Washington is pretty clear that it's actually more than pretty clear that a long-term marriage is 25 years. However, there's a whole other issue we could get into, which is about if you cohabitated with somebody before marriage for a number of years, that can expand the window that maintenance can be considered under. But that's a topic for another day. We only have so much time. So 25-year marriage, that's treated as lifetime maintenance. Is that always the case? No, and I'll explain why. But there is case law that basically says you're going to get maintenance for many years, if not life. And when I say life, that doesn't necessarily mean until you die. It necessarily means sometimes until retirement. It basically means equalization. So sometimes people hear maintenance for life and they think until this person dies. That's not necessarily true. It can basically mean until they're equalized to retirement, until retirement is equalized. And then we look at things like Social Security benefits. We look then at property division. There's a lot of number of things that we look at. But in a 25-year marriage, you're looking at how old are the parties. If the parties are 65 and it's a 35-year marriage, I've definitely had some of those, you're then looking at, okay, now we're talking about moving forward because these parties are probably done working. If these parties are done working, they need to be equalized for life. So we might then be looking at indefinite maintenance if one party has a residual stream of income that's going to come to them post-retirement and the other party doesn't. Or if one party's benefits are going to be post-divorce are going to be so much higher, their Social Security is going to be twice as much, and the property division is going to either need to be disproportionate to account for that, or there's going to need to be a regular maintenance transfer payment because the parties are going to need to be equalized. There's just no question about it. Washington courts recognize that when you're retirement age or later, the parties need to be equalized. There's just not a question about it. Where it gets tricky is spouses that are still working, that are in a long-term marriage. This is where it's not so cut and dry. And you know, more and more of these cases are kind of out of nowhere in the last, I don't know, 5 years or so, I would say, especially. There's been a big boom of long-term marriages, but people that are still late 40s, early 50s, so people that probably got married earlier, that have been together 25 years plus, and now they're getting divorced. And so you say, well, what does that look like? And I do in my personal practice a lot of long-term marriages. So there are many, I could literally talk about long-term marriages all day. I won't, but I could. So I should really like long-term marriages, because I think that you're looking at setting people up for the next chapter of their lives, and you're looking at setting people up post-divorce, new era for success. And whether that means, even if you're the spouse that's paying, you can be like, how am I being set up for success? I've got to pay this person and it stinks. But at the same time, you're looking at mitigating the damage for that person to the point that they can have some idea what those payments are going to be, what that's going to look like. If it's going to end, sometimes you can figure out a maintenance buyout. There are also options for maintenance buyouts at a discount if you're prepaying maintenance. There are ways to do a disproportionate property division in lieu of maintenance. So there's all kinds of really, I think it's fun. You probably don't, but there's fun, creative stuff that you can do in any maintenance award, but especially in long-term marriages. So if you have working years left, a lot of the time, you're really just talking about equalizing to retirement, depending on how many years that is. And then you're talking about what that's going to look like at that point in time for people. And you have to then look again at, what does retirement look like? What does the property division look like? And it's not uncommon for, you know, a 25, 26, 27-year marriage to be a 50-50 division of property plus, you know, significant 8 or 9 years of maintenance. That's not an uncommon result in a 26, 27-year marriage where there's disproportionate incomes. So anyway, long story short, 25 years plus has a whole new set of rules that often come into play. And there's a lot of creative things you can do with property division. You can do that really with any kind of maintenance package. But a lot of the time there's more assets to deal with in a long-term marriage. That's one good way to put it. A lot of people want to know about misconduct. Now I'm gonna just kind of run through. I've made some notes about things that people always ask me about, and I don't want to forget them. So I'm gonna do that, and then I'm gonna take some questions from Melissa, and then I'm probably going to talk a little bit about child support and the impact of child support on maintenance, because if anyone has kids at home and they're in a situation where they're wondering, how does child support impact my maintenance, I want to talk about that. But misconduct, so what does that mean? So Washington's a no-fault state. I don't know if anyone has heard that yet. What does that mean? Well, my spouse cheated on me. My spouse beat me up. I had to get a protection order. My wife or husband or partner ran away with a babysitter. Like, all kinds of really bad stuff happens in divorce. Divorce isn't always people just deciding that they don't love each other or don't want to be in a marriage anymore. Sometimes it is, and that's really great. But sometimes really not great, but at least it's not high conflict, what we would call. Sometimes there's mental illness. Sometimes there's substance abuse that can trigger really bad behavior. Sometimes there's just bad behavior and things that you wouldn't do to your spouse, but someone did to you that felt really bad. And you think, okay, this person should have to pay me more because this happened, or this person's at fault. Or you should think, hey, I didn't do anything wrong. And I've had clients, or I've seen clients on the other side where they're like, I didn't do anything wrong. The other person did. The other person's the one that cheated on me. The other person's the one that was abusive. And yet I have to pay them? Yes. Or vice versa. We're a no-fault state. So Washington's not going to look at issues like infidelity, domestic abuse, misconduct, or reasons that they're not going to punish a spouse for causing the divorce, is what I should say, or as a reason for allocating financial financial awards, whether it's in property division or maintenance. A lot of the time people want to use maintenance to punish, and it's really important to know that it's not that. Maintenance is either meant to be rehabilitative, it's meant to be lifestyle maintenance, which is 25 years or more. You've lived a certain life, you're used to that. You get to live that forever, basically. If it's 25 years or more and your life's been pretty great, you get to live it for a long time. But no one's going to punish somebody by making them pay maintenance because they treated you poorly. It's still going to matter how long you were married, how much people made in the marriage, what the roles were in the marriage. Those are the really important factors. And can someone afford to pay maintenance? And do you have a need? Those are kind of the basics. But a lot of time people want to know about how misconduct plays in. It really doesn't. The only way it plays in and there's crossover is if there was waste during the marriage. And this is something that really is more about a discussion for another day about community property division. Although it's kind of hard to talk about maintenance without property division too. But you know, somebody had an affair and they spent a bunch of money on flying that. I don't like to use a lot of specific things from my cases, but it's hard not to. Let's say hypothetically, you had a client who spent a bunch of money, or another party that spent a bunch of money on an affair and flew someone around in a private jet and spent community money on that. That would be really expensive, and they paid for expensive hotel stays and vacations. That's money that should have been spent on the community and not on this other person and that affair. So that could be deemed community waste. So that's something where the bad behavior is directly tied to waste, and perhaps that party that caused the waste would have to reimburse the community for the waste. That's not punishing somebody for the behavior. It's saying your behavior had a direct tie to causing the community waste because you spent community money on something that wasn't the community. Or it could easily be a situation where you have somebody who went and gambled a bunch of the family money and one spouse didn't know, and the other person was going to great lengths to hide it. That is not, unfortunately, uncommon. One spouse could have no idea and think they're doing really well financially, only to find out a bunch of the 401k was drained, and you know, somebody signed somebody's signature and there's a big loan on this 401k you didn't even know about. That's community waste. So we're a no-fault state, so we don't allocate financial resources for blame, but at the same time, community waste is something that does come up. That can be hard for people to understand. I'm just going to hit a couple more things, and then it looks like there's questions, and I don't want to miss those. Okay, one thing that's really, really, really important to understand, a lot of people ask me about this, so I did want to not skip this, is returning to school and how that plays into maintenance. People can return to school at any age. Excuse me. Sorry. People can return to school at any age. So you could be 45 years old and you could be going back to school for something. You could have never finished your bachelor's degree, or you could want to get a certificate to update your education, or you could do something totally different. And it's really important because sometimes courts will increase or lengthen maintenance if the recipient wants to return to school. And that's not always, so it's not a guarantee. So don't just think I'm going to go sign up for an online degree program and I'm going to get more maintenance. It doesn't work that way. But it can be a reason. And also too, it matters the length of your marriage, what we're dealing with. But it can be a reason because maintenance, again, especially midterm marriages, should be rehabilitative in nature. So if you're going to finish a program and that's going to give you a better income at the end, it makes more sense in your settlement to say, hey, I need to get through this 3-year program and I need a little bit of time to find a job afterwards. And maybe it gives you a reason to negotiate for a little bit longer maintenance and maybe some help with the tuition as well, or, you know, your settlement. So in returning to school, people will look at like the relative increase in maintenance, resources for the person paying the maintenance, if you can easily afford it. So if you have someone that's making, you know, a mid 6-figure income and the person going back to school is looking at trying to make $60,000 or $70,000 a year, it's more likely that it would be expected that the person who's paying the maintenance because they can afford it is going to pay that extra 10% or whatever to lengthen the maintenance and help that person go back to school. It's in the better interest of the community, and they can afford it and it's not a hardship. So also to the seriousness of the person who's really going to school. Don't say that, I've seen this come up before, don't say you're going to go to school and start a degree program and then drop out, because someone could come back and seek to modify or terminate maintenance if that was the basis for the agreement, depending on how the agreement is written. Yeah, And then also too, whether it's likely to benefit any children. If primary parent, if mom is living in the home and mom's living in the home and she has kids in the home and she's looking to go back and has no education and really no skills and needs to get something going to be able to help provide and contribute to proportional share, which we'll talk about in child support in a few minutes, then it's more likely that, you know, there's going to be support, probably in negotiation from the other side and definitely from a court to get mom or dad, if dad's in that situation, some education. So I could keep talking, but I know there's questions. Melissa, do you want to give me anything to answer just so I don't save all these till the end and not get to them?
Yeah, definitely. There's actually a number of questions here, probably enough to keep you busy for a little while. Here, let's start with the first one here. The question is, how do I know child support goes toward kid care? Can I verify the funds spent on kids?
No. Yeah, that's okay. No, I shouldn't say that. A question comes up a lot. Generally, you know what? You that's a good question for child support. I'm going to answer. Let me just give an overview of child support. Yes and no, I should say. Child support in general. Child support is meant, and I was just talking about this morning, actually. So in another conversation, what is child support for? Child support is for this. It is for basic necessities. It is for food, shelter, clothing. It is for basic necessities in life for your child. What does that mean? It means your child support can go to the other parent's rent. It means it can go to their car payment. It means it can go to their gas. It means it can go to their food bill. It means you don't get to have control over where those child support dollars go. It goes to basic necessities. Putting a roof over your child's head, putting food on the table, driving your child around. It goes to that parent to manage towards their budget for paying for your child, the residential parent. You don't get to say, this money went into, let's say mom pays child support to dad, and this money goes into dad's account, and dad's primary parent, and dad bought a latte today, and did those dollars come from child support to his latte? You don't get to do that. Some people really don't like it that the child support goes to the parent and they don't have control over what happens. That's just life. That's a transfer payment that you're making that that parent gets to use to provide for basic necessities because they have the child the majority of the time. Other part of child support where you do get to have control is for additional expenses that are not covered by the child support transfer payment. So that would be things like out-of-pocket medical, so co-pays. That would be anything that is divided along proportional share, and I can talk about that really quickly. But that could be extracurriculars for sports. That could be if your child is in counseling or goes to a medical appointment. A big one is work-related daycare. If you or your spouse needs work-related daycare and you're paying proportional share for that, you absolutely have a right to make sure that money is actually going to daycare and not to your spouse. That can be really expensive. So, you know, sometimes people are paying $1,500 a month, or who knows, maybe even more for multiple children to be in before and after care. And so you have every right to make sure that your percentage of that is going to the provider and not to your spouse to spend as they wish. But the actual child support transfer payment, you don't get to manage how those dollars are spent. More?
Yeah, of course. Here's another one for you. How do I collect child support from an ex-spouse who lost their job but is being paid under the table for various jobs? And as primary parent, do I have a right to those funds?
That's a really tough situation. Yeah, you do have a right to those funds. If you have a child support order, okay, here's the deal. If you have a child support order, you have a right to enforcement. A child support order is a court order. And if it gives you, if your spouse has lost their job and they haven't sought to modify child support, and maybe you have enforcement through DCS, through Division of Child Support, you probably stop getting payments. So you aren't getting payments because they're not getting their regular paycheck, but maybe you think or know that they're working under the table. That is unfortunately not uncommon. What do? Do you have a right to those funds? Yeah, because they're making income and they're not supporting their children. So of course you do. But what do? Well, you can do a couple different things. The most common thing you should do is get in touch with your support enforcement officer. You have one. You might not know that you have one, but you do. Contact DCS. You can also contact an attorney as well, and they can go through various options, or court enforcement, or contempt, on child support, that's a whole other thing you can do. But a really simple thing you can do is first, just don't waste so much money on attorney fees. Contact your support enforcement officer and see if you can talk to them about what's going on. You might want to do a DCS hearing, and you should get an attorney for that, in my opinion, if you do. And again, that's an opinion, it's not legal advice, but if you're going to take testimony in a DCS hearing, which is over the phone, and you're going to have question the other party about their under the table work, you could basically ask for support to be reviewed if you have a reason to believe that they are working and not reporting income. DCS only knows, what's coming in through the bank account and what's coming in through their employer. They don't know what's going on otherwise. You have a right, if you have a reasonable belief, to have hearing on that. But if you do, I recommend that you talk to an attorney. It can be a really tough situation, though, to prove out of pocket, under the table income. It can be really hard. It's not impossible. But in that kind of a situation too, you're probably going to want to see if any of that money is going into your ex-spouse's bank account, if they're dealing only in cash. There's a lot of things that can go into it, so you want to make sure it's worth your while. But I would just start by calling a support enforcement officer and seeing what's going on there and if they're willing to help you. Or if you didn't go through DCS and you just have a court order, seeking DCS enforcement if your spouse is supposed to be paying you outside of the DCS process and they just stopped and said, hey, I'm not working, that's not good enough. Get your order enforced. I could keep going on this, but I'll stop. Go ahead, more.
All right. In a long term, if one party makes more money over time, does the other party then receive more maintenance?
Depends. Depends on if one party makes more money over time. It's not really about, here's the thing. This is so unfair, some people will say. So I'll give you an example. It kind of matters the situation of the parties at or around the time of divorce. You could have a situation where, let's say, wife was the primary breadwinner for the first 5 years of marriage, okay? So she really carried the load for the first 5 years of marriage, and husband was in school and wasn't working, and then husband got through school, went back to work, and now wife had a child and stayed home for a while. So wife made a lot of money in the early years, but now she's not. And now husband has a job and he's making good money for a few years. Then they get divorced. And you look at the historical income over the marriage, well, wife historically made more over the marriage, but husband's the one with the recent education and the earning capacity. Husband's going to pay maintenance to the wife in a midterm marriage because he has the earning capacity and the ability to pay right then and there. And wife probably, this is all just hypothetical, but wife probably needs to do some things to get back in the workforce if she's been out of the workforce for a few years. And she might have made more if you add up all the years, but it's not how much they made over the course of the marriage. Really, it comes back to what I talked about in the beginning. It's about the details of your marriage. There's nothing more important than working with an attorney if you believe you have a maintenance issue on the details of your marriage and coming up with what your position is going to be on maintenance. Nobody's situation is the same. Nobody's. There are fact patterns that are very similar, but you really want to say, what happened in my marriage? What are my resources? What is post-divorce going to look like for me? And we haven't even talked about temporary maintenance. I'll talk about that briefly in a minute, but it's not about the aggregate amount. It's about the current situation. I'll take one more, Melissa, and then I'm going to talk about temporary maintenance.
Okay. What if the other parent doesn't agree on the other costs, doesn't think the kid should be in extracurricular activities, or doesn't want to pay the ask for the school?
I love that. And I love that question. I don't say that because I love that happening, but because that happens all the time. Then that veers into parenting plans. I think we talked about that on another webinar. Parenting plans. Parenting plan dictates your decision making. You should have, unless there's a basis for restrictions in your parenting plan, or unless you've agreed to sole decision making on extracurriculars, you have joint decision making. So you should have a parenting plan that dictates a process for decision making. So if parent A wants to enroll John in soccer, little Johnny in soccer, and parent B is like, oh, I don't want Johnny playing soccer, there should be a protocol to work that out. If the objection is purely financial, then maybe it really depends on what your dispute resolution is. But generally, one parent, you shouldn't be able to use decisions that are abusive just to punish, usually use the child as a pawn. But you have to have a clear decision-making protocol in your parenting plan. And it's hard for me to speak to financially how that would work without knowing what your decision-making protocol is, but the general consensus without a reason for restrictions. Restrictions can be serious substance abuse, mental health, domestic violence, and a nexus between those things and parenting functions or abandonment or neglect. If there's no restrictions saying both parents can't make decisions equally, then parents have to find a way to agree on things. And that's why crafting a solid parenting plan with a solid dispute resolution and decision-making protocol is key, so you don't run into those situations. One more. Just one more.
Okay. I have a few questions that are kind of scenarios. So maybe I'll give this one to you. Okay. Here's the fact pattern. 15-year marriage. Party A is 61 years old, an attorney. Party B is 60 years old, an engineer.
15 year, I'll try to solve your legal problem, and like if you're an attorney, you should know that, like, okay, whatever. This is like whatever. What you should do is you should come pay me for a consultation, but okay. This is for the attorneys out there. Just joking. I don't know who asked me this, but you said 15-year marriage and what? I'm totally kidding. 15-year marriage, what?
A 61-year-old attorney and a 60-year-old engineer.
Okay.
Okay. So party A, the attorney, elected not to work 10 years ago and now claims disability.
Okay.
And party B, the engineer, paid malpractice insurance licenses and dues for party A for the last 10 years. Okay. Party B was ready to retire. So I think the question is what's the duration in terms that might be imposed on party B?
Well, I guess, like, I'll tell you this. I'll tell you what number one, and I don't know who's on the call, if it's the attorney or the engineer, but I'll tell you, and you don't have to tell me, but if I'll tell you this, if you're an engineer and you paid all that stuff for attorney, number one, that stinks, especially if attorney wasn't working. But this is the thing no one likes to hear, but you allowed that to happen. And this is the thing too, to know about me. You don't want an attorney that's just going to tell you what you want to hear, because that doesn't help you later. It's not doing anyone a favor. So I would tell you this. If you came to me and you were like, but I want to be paid back for the licensing dues and the CLEs and all the stuff that's paid to maintain a professional license, I get that. But if you stayed married to someone and they didn't practice, that's something that you allowed to happen during the marriage, so nobody will reimburse you for that. You're out that money. It's just a decision that you made during the marriage. That's one part of it. But here's the thing. If you're the engineer and you're the one with the income right now in a 15-year marriage, and you're looking at paying the attorney who with a law license, theoretically, that you helped maintain and keep active, that person should be able to work, right? Well, it depends on the kind of law they practice, but let's say they should be able to work. They're educated, they should be able to work. But if they're claiming a disability, here's what you should think about. If they're claiming disability, well, then they're either on disability or they're not. So they're either on disability, meaning they either are receiving disability payments, or they are in the process of receiving disability. They're either on partial disability, full disability. I mean, what's their situation, you know? So then their maintenance should be reduced by whatever the disability payments are that they're receiving. And in a 15-year marriage, and is the disability permanent? Are they going to be able to return to work? You're 61, so you don't have a lot of working years left anyway, but it's only a 15-year marriage, so you're not looking at lifetime maintenance. I would probably, and again, I don't know what the community assets are like, but I mean, I'd want to know more about your situation, but I'm kind of thinking about it. And, you know, your 15-year marriage, maintenance is probably only going to be 3 or 4 years of maintenance anywhere. Maybe 3 to 5 is like your range of risk. So if you're looking at like a 3 to 5 year window range of risk, and you really don't have that long to get to retirement anyway. So what's this person's situation? Are they going to take Social Security early, and are they on disability? If so, their maintenance should be reduced by whatever their payments are that they're getting now. And maybe you're just paying them some rehabilitative maintenance to help get them across the line until retirement age. But you shouldn't be paying them maintenance indefinitely. And you probably, if they're not really disabled, if they're just claiming they're disabled, then, you know, you've probably got an argument about really how much you should be paying them at all. But if they haven't worked in many years, people aren't really going to care that they're an attorney or that they have a law license. They're really just going to care, are they employable? If you have an attorney that's been out of work for 10 years, nobody's going to want to hire them. So they're going to need to do something to get back in the workforce. So the question is either A, are they really on disability? B, have they worked at all recently, even for themselves? And C, are they receiving any kind of income to offset maintenance right now? And then as far as length of time, 15-year marriage, probably 3 to 5 years would be your range of risk. 3 years low end, 5 years. Again, this is not advice, this is just a range. 5 years long end. And you know, if it's a permanent disability, you could be on the hook in a worse situation, so you don't want that. If it's permanent disability, talk to me or someone else immediately if you're the engineer. But again, make sure they're really disabled. A lot of people will say, I might be disabled, and that doesn't mean anything. You're either on disability or you're not. All right, gosh, do you want me to just answer more questions? That's probably
There's
better.
more questions. There's definitely more questions.
Yeah, sure. I'll answer people's questions. People can learn from that, and then I'll hit a few more things, and then that's all you get time for.
Okay. All right. Here is one. It says if we share custody of our kids 60-40, how do we calculate child support? Simple math on DSHS site for 2 kids is about $1,000. Would one parent be responsible for 600 and the other 400?
Questions. It's not so simple, is it? So no, 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 not at all, actually. No. Then see, this is where you're gonna feel it's unfair. I don't know which one, whoever asked that out, and I don't know who's on here. So, all right. If you're in let me just give you a high level overview of child support. This will answer your questions. Okay. Parent A is residential parent. Parent B is non
60-40.
Huh?
Yeah. 60-40.
Doesn't matter. It's this thing. It doesn't matter. And I'll explain what residential and non-residential means, and then I'll talk about the 60-40. But I'm going to tell you about residential and non-residential, and I'm going to ignore the 60-40 for a minute, because in general it doesn't matter. You could be, let's say the court looks at, when courts talk about parenting plans and they talk about residential time splits, they talk in terms of 14, they talk in terms of 2-week periods, so 14 nights blocks. So that's 28 days in a month. That's not a real month, but that's like in our parenting plan world, that's kind of how many nights we're looking at. So you could have a parenting plan where one parent has 26 nights. I'm sorry, one parent has 14 nights and the other parent has just like 2 less, and one parent is still going to be primary parent. So primary residential parent is the parent that has more overnights in the month. That's your 60% parent here. It wouldn't matter if it was 51-49. Person that has more overnights calculated in a 14-day period is primary parent, okay? So in the month, 2 14-day periods. Primary parent is the one who has more overnights. Non-residential parent is the 40%, okay? And the reason I'm explaining this is because it's not so, and then I'll talk about deviations. It's not so simple with child support as you may think, especially in a 60-40 or close to a 50-50. So how you calculate child support? Child support is based on statute. It's one of the things in Washington that is actually formulaic. Maintenance is not formulaic. Property division is not formulaic, but child support is. Child support is based on the age of your children, the county that they live in, and the income of the parties. And then there's a calculator. And of course you have to look at taxes, you have to look at the amount allowed for voluntary retirement and all the other deductions that are allowed. But there is a calculation based on the income of the parties, the age of the children, and the county that you live in. There's a statutory scheme that we call it. So depending on how old your kids are, assuming you live in King Pierce or Snohomish, child support will be slightly different. There's also a bump at 12. So when your child is 12, child support goes up a little bit because at least the legislature realizes that it's expensive to feed preteens and teenage children, and that children's activities and things just to maintain them on a daily basis are more. So anyway, back to this question. Non-residential parent has 40% of the time. Residential parent has 60% of the time. So let's say you've got 2 kids. Let's say you came up with a number. You gave me, I think, a number of $1,000. That seems really low, but let's say that's, for sake of discussion, let's say that's right. I don't know anything about your incomes or your children's ages. So if the total amount of child support is $1,000 for 2 kids, that again, that seems really low. I would talk to somebody about your math or have somebody run through the numbers with you. But if that's the number that you're talking about here, then you look at the income of the parties. I also don't know who makes how much. Let's say that, let's say you guys make the same. Let's say parent B makes 50% of the income and parent A makes 50% of the income, okay? So parent A is the residential, parent B is the non-residential. That means they have less nights. Parent B is responsible for 50% of that $1,000 child support amount. Each party is responsible for $500, right? The way it would work on a 60-40 is parent B would pay their $500 to parent A. End of story. That is how it works. There would be no other transfer payment made. The reason why is that in the child support number, the non-residential parent makes the transfer payment to the parent that has more nights. That's the presumptive transfer payment. There can be reasons to deviate from that. And one of the reasons for a deviation, and this can come up in a 60-40 or a 50-50, can be a basis for deviation can be time with the children. Deviations are discretionary, which means they are not guaranteed and they're up to the discretion of the court, or parties can agree on deviations. I have parties that agree on deviations all the time. But if one parent has 40%, which is more than just an every other weekend situation, that means you are paying for food, clothing, housing, all those things we talked about that go into a child support transfer payment. You're paying for those in your house 40% of the time. And if you make equal amount of the other parent and you are paying your $500 to the 60% parent, that might not seem fair to you. Well, you could seek a deviation. There are reasons to deny a deviation. We could talk about what those are if we had more time. But generally speaking, non-residential parent pays their percentage of the child support amount based on income to the residential parent. Reasons for deviation can include time with the child, and a variety of other reasons. Reasons to deny a deviation can be if it would be a hardship on the other parent. So if the parties' incomes weren't equal and one party made a lot more and cutting back on the child support was going to really hurt the person that was getting it financially, you're not getting a deviation. So if you make a lot more than the other party, you're not going to get a deviation. Anyway, long story short, child support is formulaic, but it's not always super simple. So, okay.
You have time for maybe one more here?
I'll do
Let's see. Okay. Okay, so if the spouse paying support makes 2 years from now, as an example, $2,000 more a month than they were making, will they need to pay more maintenance beyond the initial award due to their newly realized higher income?
No, not unless it's a long-term marriage. Maintenance, this is talking about maintenance being modifiable. This is great. I was going to talk about this. We could have talked about maintenance all afternoon. I wouldn't have minded.
And I think, Michelle, I think this actually is in a longer-term marriage. So
is it? Okay.
Yeah.
Well, let's talk about that then. This is the thing too, just before I answer this, I really wouldn't mind talking about maintenance all afternoon. I really enjoy it, but I can't today, so I won't. But you should come talk to me about maintenance if you want to sometime. But anyway. Maintenance in a longer term marriage. Here's the thing to know about that. So maintenance awards in general, whether they're modifiable or not, and I wrote this down because I wanted to be sure to talk about this. I didn't get through most of the stuff I want to talk about. It's because you guys had great questions. So yeah, maintenance is modifiable by law when the parties' positions change, unless there's an agreement that it be non-modifiable. Generally speaking, if someone makes $2,000 a month more, is anyone going to see that as a basis to modify maintenance? No. The cost that you're going to have in bringing a motion to modify maintenance over $2,000 a month, no, that's just not going to happen. When maintenance in a 25-year, so that's in general, but in a 25-year marriage, in a long-term marriage where the parties are supposed to be equalized, you would likely have a maintenance award where the parties are, depending on how you structure your settlement. It depends on if you're structuring your settlement with ongoing maintenance, then you might have maintenance reviewable by an annual tax return exchange. If you're doing that, then yes, it's going to make a difference. And you've already agreed in advance that maintenance is going to be modifiable and calculated annually based on annual income by tax return. In a 25-year marriage where you've agreed 25 years or more and your retirement age and you've already agreed to equalization into perpetuity, then yes, it's going to matter. But if it's just another, if it's a 20-year maintenance, 20-year marriage, and let's say you've agreed on 6 years of maintenance and party B starts making $2,000 a month more a few years in, you're going to spend more to go back and try to modify that maintenance than you are to just accept the maintenance award that you have, probably, unless it's a big difference for you.
Okay.
Oh, you know what I should do? I should talk about this really quick.
Yeah, we just have 5 minutes, so if you want to throw, okay.
Yeah, I'll take one more too in a minute because I feel bad because the questions are probably why you guys are really here, right? But again, there's only so much we can cover with a ton of people and not a lot of time. Modifiability of maintenance, I did want to talk about that. To modify maintenance, there has to be an existing obligation. So if a divorce decree doesn't award maintenance and the parties' situations change later, I have this happen where people will come back later and say, oh, I didn't get maintenance, but things changed. Once you're done, it's done. So it's very difficult to reopen a divorce. You need to bring like a CR60 motion, which is a vacate motion. You have to have a basis to do that. You're not doing that. I shouldn't have even said that. But you're not reopening a divorce to go and get maintenance. Once it's done, it's done. So you have to have an existing obligation. So it doesn't matter, like if someone wins a lottery later, you're not getting maintenance if you didn't get it in the first place. And here's the other thing too, a divorce decree cannot include like a nominal amount of maintenance, such as $1 a month to act as a placeholder. I've had somebody tried to do that once, and that's absolutely, there's policy against that, and that's ridiculous. You can't use maintenance as a placeholder to just wait and see what happens. Maintenance terminates on remarriage generally, like that's the law, unless you have specific verbiage that makes it not terminate upon remarriage. Sometimes people will agree to that. I don't know why they would, but you can agree to that. There's very specific situations where I've seen that be appropriate, but maintenance generally typically terminates upon remarriage, absent agreement. Life insurance as security for maintenance. I'm going to touch on this because this is something really quickly that people don't talk about, and then it comes up in settlement, and it either really kind of freaks out the person who's being asked to get life insurance or the person who doesn't know that they're going to want to be asking for it. So I was trying to mention it earlier. Maintenance automatically terminates upon death. So if you have a pretty big maintenance obligation, divorce decrees or settlement agreements that are underlying for a divorce decree, which is typically what we do. We don't usually put all of your settlement information in a divorce decree because then it's in the public file. So I typically will do a property settlement agreement. Most attorneys will, that will address the terms of your separation on the financial side and will include the maintenance awards. So typically in the divorce decree, it will require the payer, the person paying maintenance, to purchase and maintain life insurance for the recipient's benefits. Some people will say this is the exception and not the norm, but I disagree with people that say that, because I think if you are, it also depends on who you're representing, but more and more a prudent settlement is going to, with a significant maintenance payout, is going to be include a life insurance. It's just going to include that. I can't imagine getting my client a huge maintenance settlement that they really need and not having a maintenance obligation secured by life insurance. That's a very normal thing to ask for, and your attorney should talk to you about it. So either on either side, either way. So if you're being asked to get life insurance, it's not personal, it's normal. And if no one's talking to you about that, that's a concern. So anyway, there's a lot of other stuff I could do. I have like 2 minutes. You know what? I'll take 1 or 2 more questions. I think that's probably better than me just talking.
Okay. If a primary co-parent doesn't tell you about standard medical appointment for a 13-year-old child, do I get to say that I don't have to pay 50% of medical payments on top of the child support, even if uncovered payments are declared in the parenting plan to be 50-50? Because medical decisions, not emergency, should also be 50-50. Any way to get child support lowered on that? Sorry, that was a lot. Are you following? And what I'm hearing is that
a lot of issues here. Number one,
yeah.
Okay, medical decisions are 50-50. I think you mean joint decisions. Decisions are, yes. Okay, let me back it up for a minute. If you have joint decisions on non-emergency medical, and which you probably do, and your co-parent didn't tell you and went and took somebody to an appointment, it's not about the monetary amount as much as it's about you need to hold them in contempt. And the reason why is because that's kind of, if you don't hold them in contempt, it's like saying it's okay. You don't necessarily have to hold them in contempt, but at least address it through email or writing, and you might want to seriously consider holding them in contempt, because that's a parenting plan violation and joint decision-making violation. And if they're doing that, they need to know they can't do that. As far as you paying for it, if you're paying a copay, if you're paying out of pocket for the whole appointment, you didn't know about it, yeah, you might want to say it's on you, you didn't tell me about it. But if it's something that your child needed, you're not going to look like really great if you're not paying for it just because you didn't know when the appointment was. The proper remedy is contempt, and if contempt is found, then you actually will be awarded your attorney's fees, because attorney's fees shall be awarded. It's a mandatory award of attorney fees, not always actual fees, but there's a mandatory award of fees on contempt. And so that's the most important thing, is tell them they're in contempt of the plan so they don't do it again. I'm not saying run to court right away, but if it's a behavioral thing and they're going to continue to violate decision making, put them on notice so they stop, because that's not okay. You guys need to co-parent together. If you're being asked, or just say, hey, I'm not going to pick up my part of the co-payment because you didn't tell me. If there's like a major bill from it, it might be worth addressing, you know, who's going to pay that how, but it doesn't get you out of your obligation necessarily.
Okay. I'm going to share a screen here with our contact information, Michelle. We really are at 2:01, and I think any other question I ask is going to be a pretty long answer.
Okay.
So why don't we wrap it up and just thank everybody for coming. We have contact information written here on the screen. So please do contact the firm. Also feel free to contact me if you have any interest in therapy services, but certainly Dellino Law Group is here and available to take calls and schedule consults. And we'll be hosting more webinars in the coming months.
Yeah, we try to do, I'll say we try to do, you know, been kind of busy lately, but try to do one a month if we can. I don't know if I'm going to have time in August, but we'll try to fit one in. So we'll keep you posted. If you're on our mailing list, you'll probably find out about others. Also, you know, if you have any follow-up comments or questions, feel free to shoot an email to either Melissa or me. Feel free to schedule a consultation with me or another attorney. If you have detailed situation about that you want to get into, and even if it isn't with us, talk to somebody. There's nothing worse than trying to go on Google to find out what you should be doing for your case. There are a million different things that you can find online. Sometimes I do things like look online and find out what symptoms I might think I have medically, and that doesn't mean that they're right. So I need to go see a doctor. If you have a legal problem, you should go see an attorney, because you could be making a major error. And I can't tell you how many times we have people come in and I wish I could help them, or I wish I could help, you know, do things differently for them, but they've already made decisions in their case based on what they thought was right. And I can see why they thought that, but they're wrong. So anyway, definitely reach out. Thanks for joining us today. It was great to get so many great questions. A lot of your questions were great. For the ones I didn't get to, I'm very sorry. I did my best. And take care and have a safe and wonderful 4th of July. Bye-bye.
Take care.